Hi, I am Cynthia Kuehl and I'm here with my colleague Lisa Munro from Lerners. We've been discussing over the last 4 episodes various topics related to arbitration. Lisa has been bringing her arbitrator's perspective and I've been bringing my perspective as counsel. In the last episode, we talked about challenging the arbitrator, and in our final and 5th episode, we're talking about a different kind of challenge, challenging the award. So no counsel wants to think that they're going to be unsuccessful. We all want to believe that we win all the time. However, the reality is that you need to turn your mind to what might happen in the event that you're unsuccessful in your arbitration. And when I say turn your mind to it, although we're talking about this now, this is the final episode in this series, the reality is you need to turn your mind to these issues at the time that you first look at that arbitration agreement. You do have 2 potential ways in which to deal with an unsuccessful outcome, an award that goes against you. One is an appeal, and the second is a set-aside. And I'll talk about set-asides in a minute, but upfront on appeals, if you're in an international arbitration, you're out of luck. International arbitrations, no appeals, doesn't matter what your agreement says. But in a domestic arbitration, it does matter what your agreement says because the way in which you can appeal and if you can appeal is determined by the language chosen by the parties in their arbitration agreement within the larger context of the Provincial Act, typically across Canada. So you need to be aware of what that agreement says, and you need to have a discussion with your client at the very outset about whether they want appeal rights that may be different than what is in their arbitration agreement. They may want to narrow those rights, they may have some confidence in their position, or they may actually just want to narrow the rights because they want to get on with things, or they may want to try to expand their rights. Clients, like many counsel still today, are more familiar and comfortable with court litigation where you can appeal just about anything. And it gives them a sense that the final decision is not the final decision. They can keep going all the way to Supreme Court. Other clients don't want that. They don't need or want that comfort. And indeed, one of the benefits of arbitration we talked about in episode 1 is choosing your arbitrator. And unlike court, you get to hand select the person who's going to decide your dispute. And hopefully that provides your client with some additional comfort when they're looking at what they can potentially appeal and what rights of appeal that they ultimately want. What the Provincial Act says is if you say nothing, you get an appeal with leave on a question of law, which is actually quite narrow because questions of law are narrow themselves, and increasingly so by virtue of the court jurisprudence. But you can write into your arbitration agreement other types of appeals, and you can also provide that no leave is required. What you need to do is do it before you know the outcome, keeping in mind that whatever appeal rights you give gets given to both parties, and if you're successful, you may regret having really expansive appeal rights, especially if what you really want to do is just move on with things. So once you get to an appeal stage, if you're unsuccessful, you can look at the act, you can look at your agreement, but more importantly, what you need to do is before you even get there, you need to be very specific in your agreement about your appeal rights so there's no controversy on that later on, and assuming not, have given some real thought to whether or not this is to the benefit of your client. Some clients may have a very good appeal, but they may say enough's enough, let's move forward. And part of this whole process, as we've talked about from the beginning, is knowing what your client actually needs and wants from this process. That's appeals. The other issue is a set-aside. Set-asides exist both in international and domestic arbitration. And set-asides are not appeals, they're applications to the court to set aside the award. And those, as you know, Lisa, are really about challenges to the process, concerns about procedural fairness, concerns that there was never any jurisdiction, though be aware you need to raise that early on as soon as possible. And those may have the effect, if successful, of starting the process all over again. So again, is that something that your client really wants from this process? And finally, I think what people need to recognize is if your client wanted confidentiality, an appeal or a set-aside takes what is a private realm dispute into the public realm. So really, your client needs to understand that some of the benefits, like speed and efficiency, because you're in the court process, and confidentiality, are now going to essentially be lost. And they may say, that's what I want because I was unsuccessful. They may say, that's not what I want. But those discussions need to be had at the beginning and at the end of the arbitration process.
As arbitrator, you know that there will always be somebody who's unhappy with your award. The losing party will always be unhappy. And so that really reinforces the importance of your role as arbitrator. You have been appointed for the sole purpose, essentially, of resolving the dispute, which means creating an award that can be enforced by the winner and one that explains to the loser why the loser didn't win. And so what does an enforceable award mean? There are statutory requirements that require a signature and for the award to be dated and those sorts of things. But what I'm really talking about is the reasons. And what you need to explain so that the losing party can understand and potentially a reviewing court can use to decide an appeal or a set-aside application is why you as arbitrator came to the decision that you did. And so what that involves is a detailed analysis to make sure that every single issue that the parties raised is dealt with in the award. And so a summary of the issue, an explanation for the reason, and a conclusion, essentially. That's what good reasons are. And those are the kinds of reasons that a reviewing court on either an appeal or a set-aside application will need in order to consider whether the award stands or not. And that's a significant part of your job. Now, the parties may have decided to eliminate an appeal route, for example, as you suggested, Cynthia, for a whole bunch of reasons. You talked about perhaps wanting an end to the process, not wanting to take a private dispute public. Sometimes it's just a matter of they just want an answer. They just want finality. And so part of the job of the arbitrator is to help with that. There are other potential shortcuts that parties can make in order to increase efficiency, reduce costs, etc. And that is another reason why sometimes parties eliminate appeals. But I would urge any party considering eliminating reasons to think that again, because of the real importance of reasons. Of course, reasons take a long time in many cases for the arbitrator to draft, and they are as an additional cost and reason for delay. But I would urge parties, if they're considering eliminating reasons, not to do so. There are recent cases that talk about that approach being Pennywise, pound foolish, and I think that's absolutely right. If all you're asking the arbitrator to do is to give you a decision without reasons, it's an extremely dissatisfying outcome for the losing party, and it makes it impossible for a reviewing court to actually decide whether there has been a problem with the process or even whether the merits decision needs to be reviewed. So this is the fifth and the last of our series of discussions about arbitration issues between Cynthia as arbitration counsel and me as arbitrator. If there's a question that we haven't answered in any of the topics that we've covered, let us know. Or if there's a topic that we haven't covered that you'd like to know something about, please do reach out to us.